Bom dia a todos, os presentes aqui e aqueles que estão nos assistindo por online. É um prazer estar aqui, um prazer poder estar dividindo com vocês um pouco da nossa visão e experiência da regulação internacional aplicável à gestão de recursos no exterior. Um prazer ainda maior poder estar aqui com dois especialistas internacionais. Eu vou falar rapidamente. A Ingrid é sócia do DeLaw, ou Deloitte Legal, responsável pela prática de investment management desde 2013. Antes disso, foi sócia de um dos maiores escritórios também em Luxemburgo. Jesse Koenig é sócio e responsável pela prática de investment management do Perkins Coie LLP, escritório americano. Ele está baseado em Washington. Então, temos aqui dois realmente grandes especialistas em regulação internacional para nos apoiar nessa discussão. O meu papel aqui é basicamente fazer uma introdução rápida da visão de um escritório de advocacia brasileiro que assessora os gestores de recursos nas suas práticas no exterior, trazer um pouquinho da nossa visão e talvez contextualizar o que a gente entende como as preocupações principais desses gestores. Depois passar a apresentação do Jesse e da Ingrid, que vão falar respectivamente de Estados Unidos e Luxemburgo / Europa, a visão obviamente mais detalhada e aprofundada desses temas que a gente vai contextualizar, e depois abriremos para perguntas e respostas. Quem estiver nos assistindo online, por favor, encaminhe pelo sistema. Quem estiver aqui, faça a pergunta, por favor, pelo microfone. Nós temos tradução simultânea, então fiquem à vontade para fazer tanto em inglês como em português, direcionados ao Jesse e à Ingrid, obviamente. E também as apresentações de cada um de nós ficará disponível no site da ANBIMA, para quem quiser depois acessar também. A minha introdução, eu dividi em alguns temas. Basicamente, de novo, nosso objetivo aqui é tentar contextualizar, os itens de preocupação da regulação internacional. Aqui eu faço um primeiro ponto. A preocupação dos gestores, eu acho que ela tem alguns ângulos distintos e eventualmente complementares. Então, o gestor que pretende ofertar os seus produtos para investidores internacionais, ou mesmo constituir um veículo lá fora para acessar esses investidores, ou simplesmente tradear ou investir nos mercados internacionais, algum ponto de preocupação em termos da regulação internacional vai existir. Obviamente, então, quanto mais você fizer desses três itens, ofertar para investidores internacionais, constituir esses veículos lá fora para acessar esses investidores e tradear os mercados internacionais, obviamente, muito mais dessa regulação internacional será aplicável a essas práticas. Nós temos uma percepção, e isso é passar um pouquinho da nossa visão, acompanhando esses gestores nas suas práticas. Os últimos anos, e aí eu vou dizer talvez década e meia, a gente viu um aumento substancial e muito importante dessa regulação. E a gente entende que isso teve três pilares centrais e principais. O primeiro foi o pós-crise de 2008. A gente viu as autoridades querendo ter muito mais informação sobre as práticas de hedge funds ou do mercado de fundos de investimento e, obviamente, proteger os seus respectivos investidores. Essa foi uma frente de regulação bastante importante. A segunda foi um combate à evasão fiscal, então um foco tributário, países isolados e organismos multilaterais nesses esforços. E o terceiro é prevenção e combate ao financiamento ao terrorismo. Essas três frentes que nós entendemos, essas três frentes principais que provocaram as autoridades a lançarem mão de diversas regulações de cada um desses países, ou mesmo a regulação multilateral. Então, passando para o primeiro ponto aqui de preocupação, o acesso aos investidores. Isso não é de hoje, isso está já nas diversas jurisdições há muito tempo. Então, cada jurisdição possui a sua regra de restrições à oferta, para que tipo de investidor, ou investidores profissionais, investidores menos qualificados. Obviamente, essa regulação é sempre maior quanto menor for a sofisticação dos investidores, tal como temos no Brasil. Os gestores, historicamente, sempre lançaram mão de regras de oferta privada, né, do private placement. Muitos das jurisdições sempre tiveram regimes que permitiam, desde que não fizesse esforços públicos dessa oferta, você estaria em compliance com as regras locais, e isso vem mudando ao longo do tempo, né? Vem mudando substancialmente. Eu penso na Europa, nós vamos falar, a Ingrid vai falar sobre a IFMD, mas é uma regra guarda-chuva, né? Uma diretiva aplicável à Comunidade Europeia, que acaba estimulando, incentivando, ou obrigando, acho que a Ingrid vai de novo tocar no tema, mas o que a gente vê é uma extinção de regimes de private placement, né? Então, esse safe harbor que gestores globais, inclusive os brasileiros, utilizavam, a tendência é que isso deixe de existir ou que isso diminua muito num horizonte de tempo. Não sei se 2018, efetivamente, provavelmente vai demorar mais tempo que isso, mas certamente é algo que precisa estar na agenda, né? A extinção dessas regras de private placement. Talvez em algum tempo, alguns países já têm essa extinção, talvez Alemanha e França já têm regras muito mais restritivas nesse sentido. Então esse é um primeiro alerta que nós fazemos. Pelas mesmas razões ainda de proteção e de transparência e de informação, as autoridades passaram a exigir, então, não só o registro ou reporting dos veículos de investimento ofertados, mas também dos próprios gestores, né? A gente vê no pós-2008 esforços da SEC, Jesse vai falar sobre isso também, em querer regular gestores que não estão dentro dos Estados Unidos, mas que ofertam as suas atividades, as suas práticas, os seus fundos para investidores americanos. E isso acontece em alguns níveis distintos, dependendo da quantidade de investidores que você está acessando, dependendo do volume de investidores, de dinheiro vindo de investidores americanos, por exemplo. Você tem a necessidade de registro full na SEC como um gestor americano, ou você tem uma isenção parcial, você cumpre alguns requisitos, fica sujeito a uma supervisão talvez um pouco mais distante da SEC, mas ainda assim sujeito, né? Então, você tem algumas, de novo, necessidades de registro do próprio gestor. A mesma coisa acontece na Europa, também através do IFMD, necessidades de compliance com regras locais, eventualmente de registro, obtenção de passaporte para que você possa ofertar em várias jurisdições. Tudo isso tanto o Jesse quanto a Ingrid tratarão nas suas respectivas apresentações, mas é que um ponto de memória que precisa estar realmente na agenda dos gestores que quiserem ofertar, constituir fundos lá fora, ofertar os seus produtos para investidores dessas jurisdições. Num outro foco que eu tinha colocado inicialmente, né, o simples trading, ou a simples negociação nesses mercados, nessas jurisdições, também muitas vezes vão ser gatilho para algum tipo de ou registro ou de requerimento de isenção ou de reporting, né? Eventualmente um pouco desses três podem estar na mesa dependendo dos ativos que estão sendo negociados ou dos mercados que estão sendo negociados. Alguns exemplos aqui: new issues, short sales durante o IPO, ou seja, são controles realizados no momento do IPO ou em momentos próximos ao IPO de uma companhia que passa a ser aberta. Regras aplicáveis a derivativos, derivativos de commodities, essa regulada pela CFTC, né, o equivalente à própria SEC, mas na parte de derivativos de commodities, isso nos Estados Unidos. Temos na Europa o MiFID II, de novo a Ingrid vai tratar sobre isso, mas que basicamente exige também uma série de controles e disclosures e políticas de soft dollars e outras coisas aplicáveis, que pode não aplicar diretamente ao próprio gestor, mas se aplica ao broker, que por sua vez vai exigir essas informações dos gestores. Enfim, tem todo um arcabouço que pode atingir o gestor brasileiro que está tradando, inclusive carteira do seu fundo local, nesses mercados internacionais. Por fim, você tem, obviamente, uma preocupação, aí sim, de jurisdição a jurisdição com relação a regras de disclosure equivalentes ao que nós temos aqui da 358, ou seja, participações relevantes, incrementos e diminuições de participações relevantes que precisam ser também informadas em cada uma dessas jurisdições. Como eu comentei, existe hoje uma carga bastante intensa de regulação com relação a combate à evasão fiscal e também a financiamento ao terrorismo. Isso a gente pode talvez resumir numa intensa busca e identificação do beneficiário final. Então a gente vê isso, e Brasil não é exceção. Brasil, a gente tem uma instituição normativa que vai exatamente nessa mesma linha, ou seja, a identificação dos beneficiários finais dos vários investimentos, e mesmo, obviamente, isso sobe muito a cadeia até onde você precisa ir para encontrar esse beneficiário final. Nós temos duas regras principais, a americana, que é a FATCA, né? O FATCA vocês certamente já ouviram e provavelmente foram provocados pelos administradores dos fundos locais, por exemplo, a respeito disso. E, globalmente, o Common Reporting Standard, o CRS, que seria o equivalente aqui, numa comparação não técnica, ao FATCA global, né? Tudo isso exige troca automática de informações. No Brasil, a gente tem, pela estrutura da indústria brasileira, a gente tem o administrador exercendo um papel muito importante para efeitos de FATCA, coisa que não acontece nos veículos lá fora, né? Nos veículos lá fora você tem uma necessidade muito mais intensa de você mesmo, gestor, dos diretores independentes, do fundo eventualmente colocados, de cumprir alguns requisitos dessas regras, né? Por exemplo, a nomeação de pessoa de contato responsável por isso. Então, a atenção a essas enfim, regras de prevenção à lavagem de dinheiro, identificação do beneficiário final, é ainda mais intensa lá fora, porque não tem o guarda-chuva ou a proteção, salvaguarda do administrador, como acontece aqui no Brasil. A gente deixa aqui algumas recomendações que na nossa prática a gente viu que, obviamente, é necessário ou de alguma forma contribui para o endereçamento dessas preocupações. Então, o primeiro ponto, ou a primeira sugestão, né, é uma discussão, ou é a intensificação da discussão pelo gestor brasileiro junto aos prestadores de serviço dos fundos lá fora. Estão me referindo aqui a administrador do fundo lá fora, ao RTA do fundo lá fora, custodiante, broker, diretor independente. Então, esses prestadores de serviço estão sujeitos a essas mesmas regras. Muitas vezes essas regras são ou coincidentes ou complementares. Então, a discussão com eles para se certificar que estão cobrindo, se os serviços que eles prestam incluem essas práticas ou esses controles ou não, a renegociação desses contratos. A gente viu, por exemplo, para ficar num dos exemplos, o FATCA, os RTAs ou os administradores responsáveis lá pelo passivo do fundo, provocando gestores nesse sentido. Mas talvez mais neste ponto e não nos demais, né? MiFID, por exemplo, é algo que a gente vê chegando. 2018, né, é o início, eu penso, mais intenso para compliance em relação a essa regra, e vemos muita pouca discussão vindo desses prestadores de serviço, a não ser dos brokers, né? Então, a conversa, eu acho que a intensificação com a conversa com esses prestadores de serviço para tentar identificar se o serviço por eles prestado cobrem essas preocupações ou não cobrem, e se cobrem, está devidamente colocado nos respectivos contratos. Então, a renegociação do escopo desses contratos é bastante relevante nesse momento. A segunda forma de talvez atingir esse mesmo objetivo é, obviamente, a discussão com assessores especialistas nos respectivos países. Aqui, obviamente, a gente está falando de consultorias especializadas, escritórios de advocacia especializados lá fora, que possam dar ou que possam trazer essas informações de maneira mais, talvez, digerida e mais prática para o caso de cada um dos gestores aí envolvidos, né? Com isso, enfim, eu concluo aqui a minha introdução. Passo a palavra primeiro para o Jesse para fazer a sua apresentação, na sequência a Ingrid, e de novo, após a apresentação dos dois, a gente vai abrir para perguntas e respostas. Então, agradeço a todos aí a atenção.
Hello, thank you, Fabio.
Só uma coisa que eu esqueci. fazerem as perguntas, podem já sendo encaminhadas.
Okay. Good morning. My name is Jesse Kanik. I'm with the law firm of Perkins Coie in Washington, D.C. First, I want to thank ANBIMA for putting this together and the whole ANBIMA team for their support in organizing this event. The topic that I will cover today is the U.S. regulatory discussion for funds and investment managers in Brazil. For my 18 years of practicing law, I have spent a great deal of time with cross-border issues for non-U.S. managers thinking of offering their investment services and fund securities into the United States, as well as plenty of regulatory issues within the United States and globally. The principal issues that I tend to deal with money managers is centered on the four main federal securities laws of the United States. First, you have the Securities Act. That relates to the issuance of securities. There's the Securities Exchange Act, which relates to the trading of securities. The Investment Company Act relates to companies that hold securities, funds. And the Investment Advisors Act, which relates to the investment advice to funds and investment advice to individuals with respect to securities. In addition to securities, there are commodities, and so I will touch briefly on Commodity Futures Trading Commission regulations that may apply in the context of regulated commodity interests in which funds or individuals may invest, and tax, which has an influence on many of the structuring decisions that we make for funds as they consider how best to offer to U.S. persons. The Securities Act of 1933, so that was adopted shortly after the Great Depression or during the Great Depression, and was intended to provide for a disclosure regime so that investors who place money into vehicles, into companies, can be assured that the companies have real assets, a real business there. There is a concept of full registration, IPOs, initial public offerings, and that requires a great deal of work to conduct in the United States. It requires a great deal of legal expense, a lot of underwriter expense, and audit standards, and then ongoing reporting. And those are the typical companies that you see listed on exchanges in the United States. Under U.S. law, there are two primary means to conduct an unregistered offering, so that the securities are not registered and all of the expenses and burdens that go with the full registration don't apply in connection with the exempt offering. One is actually for non-U.S. offerings I'll talk about briefly. For a purely Brazilian offering that has no U.S. interest, there's no U.S. compliance requirement, and many Brazilian retail funds operate without really thinking about U.S. persons. In many cases, they might say no U.S. persons. Based on the U.S. regulatory regime and the global breadth of the U.S. interest in protecting investors, it's one of those jurisdictions that your fund documents might actually specify no U.S. persons. And perhaps you don't specify with respect to every jurisdiction out there, but the U.S. has a special place based on the robustness of its enforcement program. For a non-U.S. offering, the focus really is on having no sale into the United States, no sale to U.S. persons, and no targeting of U.S. persons overseas. It can be done concurrently with what's called a Regulation D offering. A Regulation D offering is that's a term that will come up the day that you decide to offer a fund to U.S. persons. You'll call a lawyer. The lawyer will say, okay, it looks like that part of the offering will be conducted under Regulation D of the Securities Act. Regulation D requires that there be no public offering into the United States. That's step one. So there could be no website presence. There can be no public advertising, and even a seminar such as this one might need to be restricted to just accredited investors, which is a term that's used in connection with Regulation D. The accredited investor standard is applicable to both the sale and the offer. So it's not just the sale, it's the offer as well. That's why many funds in the United States, many hedge funds, private equity funds, will have a password-protected website in order to find out information about the terms of the fund, the performance of the fund. And then many non-U.S. offerors of their securities into the United States will similarly provide more information publicly to non-U.S. persons. And if somebody clicks the U.S. person button or has other indicia that they are from the United States, they will be directed toward a login in order to establish a relationship with the issuer so that the issuer is confident that it is selling only to accredited investors. And in fact, offering only to accredited investors. The next of the federal securities laws that we focus on is the Securities Exchange Act. That relates to the trading of securities and a few other aspects of transacting in securities. So first and most interesting to many Brazilian fund managers is finding U.S. investors. The means to find U.S. investors are either engaging a broker-dealer or somebody to provide capital introduction services with respect to U.S. investors. There is a regulatory framework that governs those who seek out investors on behalf of funds and other issuers. The personnel within the fund manager or the fund management entity will have similar obligations to avoid improper conduct that could raise broker-dealer issues. So, for example, we are often asked, can a portfolio manager visit U.S. prospective investors? The answer is yes, but the yes is there are certain exemptions with respect to the sales activity for issuers and their core personnel. On the other hand, it's very important that the persons not receive what's called transaction-based compensation. So a typical brokerage commission of 3% of what the person transacts in, that is generally prohibited. So in a principal who will simply receive a larger bonus at year end or will receive a greater share of equity based on the success of the enterprise, those are means to potentially compensate the person for their overall efforts, which may include some marketing into the United States. But a pure marketing person into the United States runs a risk of broker-dealer registration, and that arrangement should be carefully considered before entering the United States and offering to U.S. persons and meeting with U.S. institutions, individuals, and other investors. Something that does not arise for funds too often, but it can, is the requirement to register securities under the Exchange Act. That's a requirement for U.S. public listed companies once they have over, once a company has over 2,000 holders of record in the United States for a U.S. issuer, or for a non-U.S. issuer, over 300 holders of record in the United States. The very burdensome reporting and ongoing updating of information becomes required. And that's an issue that many funds don't have to deal with. It's a good problem to have if you have 2,000 investors in your fund, but it can arise if you have great success and maybe for a non-U.S. issuer, 300 U.S. investors. The next topic under the Exchange Act I would like to cover is Regulation M, particularly Rule 105. And Fabio mentioned this briefly, that there are issues sometimes with IPOs. And in the United States, particularly for subsequent or follow-on offerings of a public company's securities, so they go back out to the market to issue new shares, a company that engages in short selling in advance of that sale of the secondary IPO and then buys in to the secondary IPO can raise issues under Rule 105. That's an issue that has affected global managers who just haven't focused on the U.S. rules and is of particular sensitivity among international investment managers who periodically get caught up in SEC enforcement actions that wrap in 20 or 25 fund managers from the U.S. and around the world. Trading limits and reporting. So generally there's a 5% threshold with respect to public companies at which SEC filings must be made by an investment manager or perhaps by an investment fund, particularly if control will be sought by an activist manager, then an SEC filing and certain other very important rules must be followed. All of that is intended to prevent certain hostile activity in the U.S. markets with respect to with respect to instances where information might be held by some but not others, who are where somebody is seeking control over a public company. And finally, new issues. That's there's a FINRA rule. This is something that in your fund subscription agreement you will see reference to restricted persons or covered persons. And there are two FINRA rules which is the self-regulatory organization governing U.S. brokers. And a fund that will buy into a U.S. IPO must confirm that it is not giving a certain degree of exposure to persons who have special sort of inside information with respect to IPOs or the fund management business in general. And so you will see restricted person representations in typical fund subscription documents. Even globally, you'll have some non-U.S. brokers who happen to be FINRA members, and they impose this requirement on funds that plan to invest in IPOs. The Investment Company Act. So every fund must register with the SEC or be exempt. And that's every fund globally. So first there's an exception for funds that have no U.S. nexus. And many funds fall into that exception. And many Brazilian funds, retail funds that have no U.S. persons and don't offer into the United States have no concerns and don't have to worry about the Investment Company Act. Once a fund will offer shares into the United States, then the exemptions become very crucial. The main exemptions are what is called Section 3C1 or Section 3C7. And those are the main exemptions you'll see in any fund subscription agreement or description that offers to United States persons. Under Section 3C1, the requirement is that there be no public offering into the United States and that there be fewer than 100 beneficial owners. The beneficial owners test is a little bit difficult because you have to look through funds that hold a certain proportion of this fund. There's a look-through, and that's designed to prevent the exposure to the U.S. public from exceeding 100 persons by virtue of indirect exposure through a fund. Section 3C7 requires that there be no public offering, and it imposes a very high investor eligibility standard. That standard is qualified purchasers, and qualified purchasers are generally individuals with $5 million of investments or entities with $25 million of investments. The benefit of having a 3C7 fund is that you can offer to an unlimited number of investors rather than limit to 100. But it really is a very high standard and relates primarily to high net worth individuals and institutions. So it removes the lower affluent class of potential investor. That's a decision that a fund manager must make at the outset. Will they be a 3C1 or a 3C7? They cannot be both at the same time, but they can launch a 3C1 fund next to a 3C7 fund. Briefly, it is possible to fully register as an investment company in the United States, as a retail mutual fund. The main issues surrounding that are just the very extensive levels of regulation. Now, here in Brazil, there are extensive levels of regulation for retail funds and liabilities and obligations and reporting to do. In the United States, it's the same but different. There are certain different substantive requirements, different reporting, and a different compliance regime. And so as a package, it ends up being a very different compliance program from what you have in Brazil. Each equally heavy, but each one focused on different aspects of ongoing compliance. But I mention this because many Brazilian managers are interested in, for example, sub-advising a portion of a U.S. registered mutual fund, and some have done so very successfully. The main issue is that additional compliance obligations apply to sub-advisors as well, not just to the funds themselves. And so there is a lot of thinking to do before taking on that opportunity to serve as a sub-advisor to a U.S. registered mutual fund. The benefit of U.S. registered mutual funds is there really is a deep pool of capital. There's a lot of money waiting to be invested in the United States. A lot of money is looking for non-correlated returns, and Brazil and other markets that are not linked to the U.S. S&P 500 index offer real opportunities for investors who are seeking uncorrelated returns. The Investment Advisors Act, this is something that many of you in this room and on this webinar may have had to deal with. So under the Investment Advisors Act, every investment advisor must register with the SEC unless it is exempt. So the exemption for non-U.S. investment advisors is primarily for foreign private advisors, which is a term under the regulation. So no public U.S. presence. That means no holding out the firm as an investment advisor in the United States. Certainly holding out publicly outside of the United States is fine. Fewer than 15 U.S. clients plus U.S. investors in funds. So a Brazilian money manager that advises one fund that lets in U.S. persons and it lets in 16 U.S. persons now has crossed this line and no longer is eligible for the foreign private advisor exemption. The same thing goes with respect to a $25 million standard for funds, money coming from U.S. clients or investors in funds. So for a Brazilian or other non-U.S. fund manager that will accept U.S. money, if it cannot comply with these two standards, and it must comply with both, then the next step is to become an exempt reporting advisor. An exempt reporting advisor means it's exempt from full registration, but it makes periodic reports on a fairly simple form with the SEC on what's called Form ADV, which is for advisor. For a U.S. manager, the exempt reporting advisor threshold is $150 million under management. For a non-U.S. advisor that has no U.S. presence, that manages no money from within the United States, that threshold is without limit. The key is that the advisor must be an advisor solely of private funds with respect to U.S. investors. So an advisor that takes on one individual or one institutional account could find itself ineligible to rely on the advisor solely of private funds exemption under this exempt reporting advisor rule. And I note that there is also an additional exemption for advisors solely of venture capital funds. Some advisors find themselves in need of full SEC registration, and there are 12,000 investment advisors registered with the SEC. So it is done. It is burdensome. It could be expensive and require some time and attention, but it is done by many fund managers around the world, and it is something that can be done. It relates primarily to, if you look at my slide, I have a stack of paper. There's a lot of paperwork, a lot of reports to do, policies and procedures to prepare your compliance program. But in brief, first, Form ADV Part 1 and 2. That's the filing with the SEC. So Form ADV, like I said, ADV stands for advisor. You file it with the SEC. Part 1 is a census form, really just information identifying the investment advisor and describing its funds and describing some of its affiliations and its ownership and some more information. Part 2 is a narrative brochure describing about 18 to 20 topics relating to the investment advisor's business, and that Form ADV brochure is handed to the prospective clients upon engaging the advisor. There's a thick compliance manual with many required rules and many suggested and prudent rules to include. There is a personal trading code of ethics so that there is transparency within the organization of all of the holdings of the key personnel of the investment advisor. Sometimes that's controversial and sometimes that's not. It's controversial mainly when a principal of the investment advisor wishes to maintain privacy with respect to personal securities holdings and finds that they must report it in to the chief compliance officer. There are advertising rules that have certain specifications with respect to content. There's Form PF for private fund, that certain private fund managers who are registered with the SEC must file annually and sometimes quarterly depending on their size. There are restrictions on affiliated transactions, and there are certain terms required in investment management agreements. M&A is an interesting topic. So mergers and acquisitions, particularly for an SEC-registered investment advisor. We counsel a lot of fund management firms on being acquired by outside investment banks or financial firms. And there are a few key provisions in these agreements, in the sale and purchase agreement for the M&A transaction, that come out of the SEC rules and can really make a transaction burdensome or problematic, and so should be thought about well in advance of that exit. One is client consents. Many times a fund manager is deemed to have changed control once they sell their majority stake to a buyer, or even a 25% stake. So client consents can be obtained in a few ways. One way is to go out to every client, get affirmative consent. There's a process called negative consent, which can be undertaken depending on the terms of the various agreements. And then for certain U.S. retirement plan investors that the regulations protect to an extreme degree, which are called ERISA, the Employment Retirement Income Security Act, certain additional requirements with respect to consents apply. And so it's if these agreements are prepared correctly years in advance of the M&A transaction, things go well, and if they are not, or if there are 50 different forms of agreement with all the different customers, then it can become very complicated. Sales of affiliated brokers also have a certain regulatory process in the United States. The CFTC, the Commodity Futures Trading Commission, regulates derivatives transactions, swaps. It plays into ISDAs, which the documentation underlying many derivatives trades, and can result in the application of regulations to investment managers that engage in this kind of conduct. A common exemption is what's called Rule 4.13A3, and that is for a fund manager who limits the extent of exposure with respect to one of two thresholds. One is a 5% initial margin limit. It's keeping initial margin below 5% of the liquidation value of the company, or keeping notional value of the regulated positions below 100% of the liquidation value of the company. And that may be more detailed than you need, but as you consider having U.S. presence, then it's worth thinking about this rule, this exemption, and it is not self-executing. What that means is a filing needs to be made to claim the exemption, and so that is a common one-pager, very simple filing that many fund managers make, some forget to make, and clearly it's best if they do not forget to make that filing. Just very briefly on the various investor eligibility standards that apply in the United States. Anybody who has seen a fund subscription agreement that spells out all these investment eligibility standards will wonder why do I have to worry if someone is an accredited investor, a qualified client, a qualified purchaser. The slide says etc., but there's others: eligible contract participant and qualified eligible person and restricted person, covered person. The SEC and FINRA and the CFTC, and for various other reasons, have all adopted many different investor eligibility standards depending on the circumstance. And so these check boxes seem sort of annoying, but they all come from various rules and regulations, and all apply slightly differently to somewhat different investors. For example, no one category covers all the others. A qualified purchaser standard is higher than an accredited investor standard for most, but there are some exceptions, such as for trusts. And it gets complicated and is worth paying attention to depending on the type of investor who is coming in. I'll talk briefly about structuring. Everybody will have heard about master feeder structures, U.S. offshore structures that involve master feeder funds. And one of the common ways that U.S. funds are structured is to have a non-U.S. master fund to hold the portfolio. And for that fund, typically non-U.S. persons will invest, and U.S. tax-exempt investors like endowments, pension plans, other investors who under U.S. law should not be subject to tax. Then on the U.S. side, there will be a U.S. feeder for U.S. taxable investors. They will typically want to invest in a U.S. vehicle because they otherwise have to file a financial report for offshore holdings that is a hassle, and so they decide to invest in an onshore vehicle. And then the master fund for U.S. tax purposes is normally taxed as a partnership rather than a corporation. Corporation is opaque, a partnership is transparent. And so to avoid draconian U.S. tax rules, the U.S. feeder will invest into an offshore partnership form that ultimately allows all gains and losses to pass through to the investor and eliminate the avoidance of taxes and keep the tax results reasonable for the investor so that they are not hit with any penalties for investing in a tax-advantaged vehicle. So this slide, what to expect under the new administration. There have been several interesting signals from the SEC. So first, from the administration as a whole, there's the idea of having lighter regulation, having greater capital formation, really allowing the market to determine the risk that investors should be able to take on, rather than having the government decide on the risk that investors should be eligible to take on. In reality, at the SEC, that move has not come to pass yet, meaning the SEC has not yet moved to an anti-regulatory mode. To do so, it would require a great deal of rulemaking, which takes time. What can happen immediately is a lighter enforcement regime, so that the enforcement of the laws could become lighter. The tone, however, from the SEC chairman has been that will not be the case, that it is important to fight fraud, disclosure issues, substantive issues, and to take enforcement very seriously. I include a quote which just shows that the SEC chairman, Jay Clayton, views the past structure, the regulatory structure in the U.S. markets, as appropriate for moving forward, saying, I believe in the regulatory architecture that has governed the securities markets since 1933, and that wholesale changes would not make sense. That is a signal that this administration is not planning to remove the regulatory framework. It might make some modifications, but the overall regulatory framework should be expected to stay in place, and all of the topics that I covered should be the status quo for the most part. Now, here's a topic that is not the status quo. So new developments and thinking about the future. Fintech in general is a hot topic. Automated processes for trading with algorithms, what the U.S. calls robo-advisors, where an internet platform can accept a person's age, risk tolerance, history, and then implement an automated trading relationship, investment advisory relationship with that investor. Traditionally, the U.S. has required more personal attention in order to fulfill the fiduciary duty, but this robo-advisor concept has taken on, has become very popular. It is much easier for investors who have $1,000 to find an investment advisor now, versus requiring $100,000 or $1 million in order to have an investment advisory program set up for the investor. Back office technology enhancements are something that we're going to continue to see. It's not that glamorous, but things will become more efficient. But I want to mention briefly the blockchain technology developments. I've spent a great deal of time this year and in the past 3 years on blockchain matters. So everything from Bitcoin to standard virtual currencies to more exotic concepts like tokens that do something, that have a utility, or tokens that represent a security, so tokenized securities. And either a token is a security or it's not. And by the way, it could also be a commodity, and generally is and could be regulated in the US. But focusing on securities, a token that is not a security must take a lot of steps to ensure that it remains not a security in the public's eye. The likelihood that the regulators could deem there to be fraud based on the mistaken expectations of the investment public, of the investing public, are real. And so, but the real interesting developments are in tokenized securities. Under U.S. law, in order to trade securities, I mentioned the Securities Exchange Act earlier. That Securities Exchange Act requires an exchange in order to match buyers and sellers and automate the trade. Now, blockchain technology is perfect for matching buyers and sellers and automating trades. The problem is these platforms look like they meet the definition of exchange. There is a lighter version of exchange called an alternative trading system. And what you'll see in the current developments is the establishment of alternative trading systems in tokenized securities that then seek to fulfill all of the various requirements applicable to alternative trading systems and the other rules that I talked about today, such as 2,000 record holders. So if a tokenized security trades among more than 2,000 persons, maybe it needs to register under the Exchange Act, which is a very burdensome process. So can they prevent over 2,000 investors from investing in this freely tradable token? That's just one of the many issues, and there will be more to come on blockchain technology. It's very clear that it is like the new internet or the new website or the new email. Once upon a time, nobody had internet, nobody had emails, and now we can't live without it. and it's not clear who the winners will be on blockchain technology, but that type of technology is clearly going to be integral to the financial markets in the near future, and it's a fascinating area to watch. And with that brief glimpse into the future, I would conclude my remarks.
Thank you very much, Jesse. So we'll follow on with Ingrid from the Luxembourg and Europe part, and after that we'll have the questions. Thank you.
Então, bom dia, senhor e senhora. Inicialmente eu achava fazer a apresentação em português, mas hoje de manhã acho que é muito complicado mesmo. Então, vou trocar para inglês. A boa coisa é que eu sou aqui mesmo. Então, vou só levar o... Então, peço desculpa para as pessoas do meu webinar. Depois vai ter os slides também em português que eu vou despachar. Tá? So today I will maybe mainly focus on AIFM and funds than securities. So please excuse me if I have no focus really on securities and capital markets in these slides. But I would say that for the time being, it's still the main topic in Europe, AIFMD and how it works. Even though for some it might all be clear, it's not always so clear cut. I have put some definitions for you to recap when you will have the slides at home. It will be easier because to understand the concepts of what is an AIFM, what is exactly the EU. It's not EU, it's also some related countries. What we mean by management, what we mean by raising capital. Maybe I will have a specific point on what it means raising capital in Europe, because actually you can benefit from not easily, but from some AIFM exemptions. So the AIFMD stands for Directive on Alternative Investment Fund Managers, which would manage or distribute funds in Luxembourg. Each time you have an element, a criteria which links the asset manager to Europe. Either it is European or the fund is European. There are some exclusions, and it can be a topic of discussions when you have companies, holding companies, SOPAFIs, meaning companies working like a fund, but with some limitation in what they do. So at the beginning of the AIFMD, there were discussions about is a holding company a fund subject to AIFM or not. So it appears that, for instance, when it is just not operating as such, it's not a commercial company with operational aspects, then it is outside the AIFM. We'll focus on the distribution. Passports. What does it mean when we distribute? How can I distribute my fund in Europe if I manage a non-EU fund or if I manage a EU fund? So the AIFM marketing has a definition, which is any direct or indirect offering or placement at the initiative of the AIFM or on behalf of the latter of units in a fund it manages to EU investors. So of course you have also always this criteria of I have EU investors, I am willing to raise capital within the Europe, then I need to take care of AIFM. Do I fall into the scope of the AIFM or not? You have some exemptions that we will see, but there is one huge exemption, which is reverse solicitation, which could apply on a case-by-case basis, but reverse solicitation is not harmonized. So you need to see at the level of each member states of the EU whether you can rely on that exemption. This is something I would maybe not recommend today, because this is not really a viable marketing strategy as such. So we will review with you several cases, hypotheses of I am a non-EU fund, AIF, but I have a Luxembourg AIFM. You could imagine that you're managing your fund and you want to appoint a Luxembourg AIFM or EU AIFM to benefit from the EU passport. That could be something foreseeable for you. So it would mean that you would not be directly managing your AIF, your fund anymore, for instance, but you would appoint, or the fund would appoint a EU or Luxembourg AIFM, and the AIFM would subdelegate to you the management of that fund. Afterwards, it's a question of control of your funds, indeed. But that would be a possibility. Then you have the benefit of the passport for professional investors by opposition to retail investors, so qualified investors, I would say, to simplify it. And there are some notification process to be complied with the local authorities. I have seen for Luxembourg, but that would be the same for France or other countries. And you will have to have a notification for each of the country you consider. If you have a non-EU IF still and a Luxembourg or EU IFM, you can also market without the passport to potential investors under certain conditions, which are laid down here after. Then you have also to consider the situation of location of the IFM, whether there are cooperation agreements in place, whether it is a GAFI compliant, a FAT compliant country or not. If it's not a FAT compliant country, you would not be eligible. So we'll see you'll see that there is a lot of granularity in the rules, and then you have to choose your case to see what would be applicable to you. The other case would be a non-EU IFM plus a EU IFM, meaning the manager would be Brazilian and the fund would be European. Do I need to register, and what are the conditions to passport? Again, you need a prior authorization in your member state of reference. That would be the state where you have your funds, actually. And if you want to benefit from a passport, you will need to notify in all the other countries of the EU. Article 39, you have the possibility to market with a passport, again, your EUIF, under the conditions that you can see. Again, it's always more or less the same conditions, cooperation between countries, the host country and the home country of the manager, if I may say so, or the funds, FAT compliance, or if you don't have cooperation, it's a bit more important requirement, which would be a memorandum of understanding between the companies, the countries. Still, you have non-EU IFM and non-EU IF. You would say, at the end of the day, I don't have any criteria related to EU, but if you want to market your Brazilian fund as a Brazilian asset manager into Europe, you also have some requirements to be done. The question after that we'll see is whether still you can rely on private placement rules or not. As you mentioned, this is something which might not be viable on the long term because it will disappear in any case, if not already disappeared. You saw marketing of still your non-EU IFM with an IF, be it Luxembourg or not. Indeed, you can market a private investor with national private placement regimes under certain conditions. We have seen, as you mentioned, that national private placement regime is not yet harmonized. It is to be harmonized, we hope, next year. For the time being, there is no real discussion about it, in the sense that we don't have any text to rely and to analyze in this respect. I have put some questions anticipating your question, maybe, where are non-EU IFs allowed to market IF to potential investors in Luxembourg without a passport? Yes, we have seen that we need to notify. It's a notification, theoretically, and not an approbation. Is it necessary to notify the CSF for the marketing to potential investor without a passport? Also, yes, without or with the passport, that's the same regime. If you stop the marketing, you also need to notify. You will have some reporting requirements applying, and you will have also some requirements related to the remuneration policy applicable to your management company in Brazil that will apply, and that will be local rules that you will have to comply with. You can also maybe distribute to retail investors if that would be within the scope of your marketing strategy under certain conditions, which are quite restrictive according to each of the countries, because it is something which has been left a little bit more to the discretion of each of the EU countries. So you will see that there are some requirements applying, more restrictive requirements applying when you would like to target retail investors in the EU, because you have some restrictions at the level of the calculation of the net asset value, borrowing restrictions. You have restrictions at the level of investments. When you invest, you cannot invest more than 10% per issuer on listed securities. You need to have risk spreading. So the marketing IF in the EU, the third country IFM passport, is something which has been provided for since ever in the directive. It should have been in place since 2015, meaning that you could, as Brazilian asset manager of a Brazilian fund, benefit from a passport as if you would be in the EU. And it's unlikely, it has not happened because there are some discussions about the equivalence of certain countries, and then there has been discussions at the ESMA level to determine what would be the countries that could be eligible as equivalent. For the time being, there is no position on all the countries that would be concerned, and the EU Commission would need to have a clear view on what to decide. So for the time being, they decided not to do anything. The other option would have been to decide, I allow the third country passport for the countries on which the ESMA took an opinion, or I choose within these countries some specific countries for which I would agree to give the passport, or I extend in any case to all the countries. And for the time being, it's a status quo. So it's a bit tricky because you have texts, European texts, which do not match with the reality. And there is a technical issue, there is no sanction in text. So there is no way to oblige EU legislator to do something. So for the time being, it's wait and see. It's not satisfactory to anyone, but that's the situation in any case. And indeed, there are some other topics in the EU with the Brexit now, which are delaying even more these questions. Private placement regime, as I said, which would have had the private placement regime regulation in place, or at least in the pipeline, which is not the case. The point is that it will disappear on a national basis in 2018, meaning next year. Failing, we don't have any EU regulation. So the question here today is, will it disappear if we don't have something at the EU level to replace it, or will it still be applicable? As I mentioned beforehand, I think that private placement regime that you would be using, I guess, for distributing funds in Europe is not a viable solution on the long term in any case, but also for some countries which are maybe less favorable than others, especially as you mentioned, France and Germany, we maybe go directly to France, so they just remove the private placement regime, like Germany when they implemented the IFM. So even though you would be touching one French investor, you will have to register. So it's not only registration, it's prior authorization regime. And in Germany, it's a bit different, it's a notification regime. So you don't have to wait for authorization per se. In Luxembourg, it's not so clear-cut. Because we don't have a legislative position about availability of a national private placement regime. We have a regulator position, which is in a text which is not binding by law. So for the legal people in the assistance, that could be of interest if you want to challenge the regulator. Maybe that's not the point. But then the text refers to a placement regime and not to private placement regime. So we could maybe find a way there to discuss, but I'm not sure that as a strategy, again, that would be viable and not maybe prudent for you to rely on that. So they took a position and they put some prerequisites to be complied with when you offer to Luxembourg investors. It's merely also related or similar to what you can find in what has been called the prospectus law in terms of offer, the number of persons, the qualification of persons, whether they are existing clients or not. So in Luxembourg, contrary to France, when you want to register, it's a notification, so you don't have to wait for approval. And once you have notified, you can start distributing. So that's the text. In practice, they want you to wait for the authorization. So beside the text, you have also to know the market practice of the regulator. This is maybe a bit tricky. I guess that in the US you have maybe the same. But it's in Europe, I would say it's really less harmonized because you have these federation aspects that you have in the US. Also, we discussed previously that you have the possibility to rely on what is called reverse solicitation. the concept not having been harmonized, you have to dig into the law of each of the countries you want to target to see what is authorized or what is not authorized and what it means, because it does not mean the same in each of the countries. Some are more flexible than others. In Luxembourg, the definition is quite flexible. Indeed, in the UK, it's really flexible also. But in France and in Germany, it's quite more restrictive, and it's not always available also to retail and professional investors. It depends upon the country. So for some countries, it is available only for professional investors. For some countries, also to retail. Other countries also limit to closed-ended funds. So it's a bit tricky. You need to have a sort of checklist where you have a mapping of all the countries. I think that would be the easiest for you to understand what needs to be done. In Italy, I'm not sure it's for interest for some people here, you have a double layer of notification because you have two regulatory authorities supervising funds and the IFM passports. You have the Bank of Italia and the Consob, so it's a notification and they all work together on the file. Again, it's not an authorization procedure contrary to France and Germany. The outcome is that we don't have a clear view of what should be done in terms of private placement regime, because you've got the regulators' view, which are usually not always clear. You don't have harmonization, and you need also to bear in mind that you have sanctions. If you're not compliant, sanctions can be standard sanctions, which would be nullity of the contract with the investor, but you have also administrative sanctions, which would be fined by the regulators, and in some countries criminal sanctions, which is not so nice. So in Luxembourg we don't have criminal sanctions, so you can come to Luxembourg to distribute, but the country is quite small, so it might not be of interest. With the national private placement regime, I think it's something which maybe outside EU, I see a bit more asset managers resorting to it. But when it comes to European asset managers, they do not use it anymore, really, because it's really too tricky. It also depends upon, at the end of the day, the number of investors for some countries like Luxembourg. We have at the level of the IFM also some requirements at the level of the management. Beforehand we saw that when you want to raise capital from Europe and from European investor, you have to comply with certain conditions and prerequisites and check whether you're in the scope or not. When you want to manage European funds, that would be the same. You have also prerequisites and you need to register or be authorized fully. Either if you manage directly as IFM, I would say, even though we saw that it is not yet applicable, but also by delegation. Why by delegation? Because as a Brazilian asset manager, indeed you could be appointed as a delegated manager by European IFM. The point is that usually to be able for the EU IFM to comply with its own rules, they require you to comply with their rules. So you end up in analyzing the granularity of all the requirements. I'm sure that we can find some differences. I'm not sure whether there are really some huge differences for having done the exercise with the US asset managers or advisors. More or less it's the same or equivalent. So this is something that is quite standard because they cannot confirm they comply with their rules if you are doing something that would be maybe not in line with EU requirements. So you cannot rely on sort of delegation exemption that does not exist per se in practice. As I said previously, we have some exemptions that could apply for management or EUFM application more largely. And then the easiest one would be to be out of scope, to be able to have your fund not qualifying as alternative investment fund within the meaning of the directive, which applies more particularly to private dedicated funds. Imagine you have a wealthy family, you managing the assets and you set up a fund in Europe. Then if you have investors only belonging to the family, and have seen families of more than 300 persons, then you can be exempted from the IFM because you do not qualify as an IF. So that's the easiest one when you do private wealth management with your funds, but not always easy to comply with. You have also the exemption where you have a group of companies or where the IF is dedicated to the IFM or mother sister companies. And then you have what is called the de minimis exemption, which is not an exemption per se, but which is a lighter regime. So if you're, the fund you're managing has assets under management, including leverage, in below 100 million of euros or 500 million of euros without leverage and with no redemption rights during 5 years, then you don't have to be fully authorized. You can rely on authorization. But as soon as your asset under management would be breaching this threshold, you have to inquire yourself whether it is for the long term or not, and then you have a short period of time to file an application for full authorization, which for you as Brazilian asset manager might be a bit tricky, because today you cannot apply for authorization because, as we discussed, the EU legislator, the EU Commission, didn't take a position about third countries' passport. So just turning around around this topic. What I see in practice, and sometimes what we recommend also, is to segregate the funds, because if you stay below the radars, for instance, instead of setting up an umbrella fund with several compartments within the same legal entity, you create separated funds and you create each time a separated asset manager locally, or if you have several companies, and then you could be below the radar as such. So it works for certain structuring and certain clients, but not all of them. Obviously, if your name is Goldman Sachs, it does not work because the assets under management will be assessed at the level of the manager and not the fund itself. So you need to be really careful about how you segregate your businesses. But if you do that, if you are below the threshold, you have passport, and then you have to rely on national private investment regime, with what we said beforehand. You can nonetheless maybe register on a country-by-country basis without the passport, with the notification process that we have seen. So you have to maybe to see what would be available to you in terms of less costly and less burden some possibilities. We discussed the delegation regime beforehand. While I say you can consider appointing, or the fund can consider appointing a UIFM, and then you would be delegated the management. You need to be authorized and you need to comply with some prerequisites. The text does not require you per se to be supervised and authorized in your home country, and leaves also to the member states some flexibility, but in practice it results that each of the countries are requiring that the delegate would be regulated and supervised. I think this is legally challengeable, but no one dared to challenge that. This article is the same for the passport and for the distribution passport and management passport. Again, you will see that we have several possibilities, several cases with specific requirements. I will not, maybe you will see the slides, I will not maybe go into the details. If you have questions, then I will be happy to take the questions for the sake of time. With respect to trading limits, I do not foresee for them here capital markets limits, but merely AIFM limits, I would say. We also have, as you mentioned, I guess one of you, when you acquire major holding of listed companies, public companies or non-listed companies, you have to declare. So listed companies, capital market threshold starts from 5%. For the IFM, if you invest in private equity and start acquiring private companies in Europe, you also have declaration thresholds starting at 10%. So you're not escaping in any case. MiFID II, which will be maybe of interest for you. Depending upon what you're doing, actually, if you're only managing funds or if you're also doing some MiFID-related services. So it is deemed to enter into force in a couple of months next year. There are still discussions and technical standards which have been adopted. We still have clients in Europe which are not ready, which will just start discussing now, how can I do that, how can I implement that? So I think it's not really clear, and when you see clearance with the regulator, regulators, sometimes you don't have answers, so it's a bit tricky also for us in Europe, not only for you. So the key changes is really the trend of strengthening the governance and organizational rules, the protection of investors, also the control, I would say, on transactions, transaction reportings, and how you interact with the market. There should be a third country regime shortly. Also in this respect, I hope it will be easier to implement as the IFMD. I'm sure it will be easier. For the time being, there's no discussion really around that topic in Europe, at least. The impact of MiFID is direct or indirect for you as Brazilian asset manager, depending upon what you actually carry out as services, and if you're dealing or not with European broker-dealers or counterparties, you will be more or less impacted. So it depends whether you trade using algorithm. This is something you mentioned. Whether you do have inducement-based execution or not in place when you're dealing with broker dealers in Europe. You can also have a more direct impact if, I guess, some of you you have companies of the group in the UK. They would be, for the time being, impacted by MiFID, and they could also decide to adopt MiFID rules for all the group, and then you would be in the scope of MiFID and have to comply with. Again, the impact can be limited or not. It really depends upon analysis on a case-by-case basis. What we see as most preoccupation is related to inducement. Am I still able to make my money whilst I'm retroceding some fees or not? And we usually review all the remuneration policies and flow of fees to see what could be viable for the clients and how much money they would lose and how they can restructure their business to be compliant or maybe to be sort of out of scope. In relation to soft dollar arrangements also, there is a split between the service and the fees. I don't know whether in the US that would be the same, but that also has a huge impact on MiFID firms. So at the end of the day, we see an increase of the costs at all levels, IFM level, so management and MiFID firms, because of the regulatory burden. Third country equivalence passport, as we said, it will be in place shortly, so I hope it will be easier for you. But you need to analyze whether you're within the group or not. We have some retail consideration by opposition or professional investors considerations, because requirements are not always the same whether you target retail investors, whether you service retail investors or institutional investors, professional investors. So you would have different regime applicable to you and different requirements. And it depends also whether you do resort to the establishment of a branch in Europe, if you consider that, or on the liberty to exercise cross-border services. CRS, which would be the equivalent or the answer from Europe to FATCA, Common Reporting Standard. So it's an OECD requirements for cooperation and transparency between authorities on tax aspects for investors. Usually it is dealt with at the level of the administrator of the fund, putting in place, even though the fund would be in scope, the administrator would deal with the practical aspects and have the platform to deal with that. So the key aspects, I think, from this slide should be renamed as what are actually the difficulties of CRS, and the difficulties arise from the multiple reporting cases available, the differences between CRS and FATCA, and the possible link between the different CRS local reporting regimes or not. It's quite tricky. I will have for you, sorry, it's on another slide. I had an example for you about what could be a potential regime and what would be the implication of the potential regime. So usually what we recommend to clients is to be in the scope and to file nil reporting because it's easier from a compliance standpoint and it avoids you to be in breach of these CRS tax requirements. I'm not a tax specialist, so it's not really my stuff. I usually ask my colleagues. Impact of Brexit. I don't know to what extent you do resort to broker in or services providers in the UK to target EU. But then you might have to reconsider your business model depending upon the outcome of the Brexit discussions. You know that UK decided to exit the EU, and it's not clear today whether there would be a hard Brexit or not, even though everyone is speaking about that. For the timing, it's still impossible to determine what would be the outcome. In the UK, they are quite comfortable and they think that no one can consider that UK will not remain a EU financial center because there is no one able to replace the city in the EU. I'm not sure this will be the case because we see that Germany is quite tough in the discussion with the UK and not willing to have a nice common understanding and if the UK wins some benefits. So the Germans to take the view that they have chosen to leave, so they should be treated as a third country. In any case, they still have implemented most of the EU directives. They are still now also going to implement all the texts that would be from direct application to be sure that they could have equivalencies between their laws and the EU laws to be in a better position to discuss with the EU authorities the outcome. So I think this is indeed quite smart to do that, and we don't know what will be decided, but at least it would mean that in the UK you would have all the EU text already applicable so that it would be fully equivalent as at the day they would not be part of the EU. The Brexit has a direct impact on fund and asset managers. So for the funds, you have to differentiate whether you are UCITS. I don't know whether you're familiar with that, but that's a fund which is coordinated, so harmonized. So there is normalization at the level of the product. So if you create a UCITS in Italy, in Germany, in France, you can passport it easily, and the host country cannot comment on the product, even though they would not agree because you're huge derivative and you have a lot of leverage. If that's allowed in one country, they cannot comment on that. So these funds, they would lose their passport, so it means that they could not, UK UCITS OIC, for the UK could not be distributed anymore per se in the EU, at least through the passport. So they would need to register in each of the countries in which they are currently registered for distribution separately if they want to continue that. An option would be to create a parallel fund, meaning I have my UK OIC investing in listed assets, obviously, and derivatives, and then I do a parallel fund investing in the same portfolio in Europe, and then that fund can be passported in all the other EU countries. I think this is the less costly solution in any case. More or less the situation with non-UCITS harmonized funds, but AIF, Alternative Investment Fund, foreseen by the AFMD, would be more or less the same, except that in the directive, in the text, you can, in the future, you would be able, we hope soon, to rely on a third country passport. So it means that theoretically next year we should have clearance on that, and that if you would have an AIF in the UK distributing in the EU, continental EU, they could continue to distribute to the extent the passport is in place. More or less at the level of asset managers, if you have a UK asset management company, MiFID management company, that should be the same, meaning they should benefit from the third country passport shortly. If you have an OIC, a UCITS management company, there will be no management passport anymore. So the choice is to analyze, and we'll see that after, to analyze your business model to see whether you're more UK focused or more EU focused. If you're more UK focused, you don't have a lot of impact. If you're EU focused, maybe you should either redomicile or set up another asset management company. And for IFMs, meaning subject to IFMD, then potentially we have also the third country passport shortly. So this is the question: what should I say? What should I do when the Brexit comes? So it depends really upon your business model and what you're doing. So it's really on a case-by-case basis when we advise clients. On this slide, I have differentiated the UK aspect from the EU aspects. So I'm an IF located in the UK. What should I do? So I transfer the portfolio, or I redomicile, or I create a parallel fund. I'm a EU fund, UCITS. Can I still distribute in the UK? Yes or no? I am an IFM, a French IFM. How can I target still UK investors? The same for asset management companies. If I'm a UK asset management company and I'm focused on UK funds, a priori there is no huge impact. If a UK asset management company managing European continental Europe funds, I will need to see whether these funds are UCITS or not UCITS, whether I can have a third country passport or not. So what we see currently is redomiciliation of banks to Germany. Funds are relocating either to Ireland or to Luxembourg, because these are the main places for funds. Luxembourg first, not because I'm from Luxembourg, but on the paper, in terms of number, that's the second place worldwide for funds. And Ireland because of cultural reasons, and also because it's a flexible regime. Redomiciliation to funds, not really. HSBC said they would redomicile to funds. We need to see, because the difference also with funds is that usually they speak just French, and for UK asset managers and the population, because when you redomicile, you have to consider that you cannot just say, okay, I redomicile the company and I need to have 30,000 people, because in Europe, countries are small and maybe you don't have the resources. So usually when they redomicile with their employees or the managers or the top management. So it's not a question of authorization and technicality, it's also a human question and human resources question. So it's not so easy, because you cannot imagine finding on site all the population and technical guys able to service you, and there is no availability of this number of people, especially in Luxembourg, I would say. What we also see a lot is that people redomiciling or companies redomiciling from the UK tend to consider that there is no real requirements locally in continental Europe for whatever reason, even though we have directives. They could consider that maybe they can just put a registered office in continental Europe and that's it. Now, as I said, you need to redomicile substance. So you cannot just say, I have the registered office and I have services providers on site. So there are a prohibition of the letterbox entities to have empty companies in, let's say, Paris or Frankfurt, as I mentioned, and actually the real operational aspects remaining in the UK. This is not viable, and that would not be viable from a tax standpoint, but also from a regulatory standpoint, that would be requalified. So what you need to redomicile is indeed usually conducting officers, so senior managers, audit functions. So there are some functions which are required to be on site if you redomicile to Paris or to Frankfurt. So compliance officers need to be on site. This is the 4 I's principle according to MiFID. Compliance audit, internal audit needs to be on site. So you could imagine outsourcing some functions, still keeping some functions still in the UK, like risk, for instance, whilst the liability would remain in the home country-wise when redomiciled. And this is also to be analyzed on a case-by-case, country-by-country basis, because the exact requirements are not the same. This is why it's not so easy for these companies willing to redomicile, is that to understand what is the regulatory burden of each countries beside the text that I have in front of me. I can take questions afterwards. There are 2 additional topics on which I wanted to touch bases. It's GDPR, which stands for General Data Protection Regulation. That's a EU regulation, so we say, okay, but I'm not concerned. I'm in Brazil. Actually, the change compared to the other set of rules is that it applies actually to non-EU data controller that would process data relating to EU citizens or EU domiciled people. So if you have processing of data for whatever reason of EU citizens, even though you're in Brazil, you would be in the scope. I think it's quite important because you have a lot of technicality in what you would need to implement. And it comes into force next year. So, for instance, if you're targeting EU investors on a private placement basis, for instance, under IFM, I would suppose that you're processing subscription forms of these investors. So you would be the data controller. So the fund in Brazil would be the data controller. And then you would be in the scope of that regulation. So you have to implement some technical stuff. We can discuss that. Beside the legal aspects, it's really also a question of technicity. So we have seen also that there is a prohibition to transfer data outside the EU, except adequate standard of protection. There have been some discussions with the US, lengthy discussion maybe, about the safe harbor clause or not. The difference maybe with the former regulation is that the equivalency will be decided at EU level now. So that will be harmonized. It will also mean maybe a lack of flexibility in this respect. Objectivity maybe when compared to the US. You can comment after that. You need to carry out then a data impact assessment and privacy impact assessment to see exactly what kind of data you're processing, how the data are flowing within the group, etc., etc. It's really a tricky matter because from the outside, at least for me as a lawyer, said, okay, then you have the text and then you have to do that, that and that. But you will see in this slide that it's not so easy to implement because you have new rights and you have technical rights which should be embedded in the process itself from a technological standpoint. And we don't have any clearance of what it means and how we can achieve that. Because it's really a question of parameters, technical parameters of programmation. It's not easy. For instance, also you have, I think it's the third bullet point, cybersecurity by design and by default. So the compliance with the rules should be embedded technically in your processing itself. And it's quite difficult to understand because then you have discussions between lawyers and technical guys, IT guys. And it's really an IT question. There are new rights which also I think are a bit difficult to meet because you have the right to be forgotten, which has been replaced by the right to be erased. So let's imagine today you have your European investors and then they subscribe and they redeem and they exit the fund. And once they exit the fund, they said, okay, I want to be erased. All my data. But technically, at least I'm not an IT person, but technically, once it is in the system, IT or you can never be erased technically. So this is what the IT guys are saying. So we have requirements which is actually difficult to meet in practice. So maybe they can. It's an obligation of results, and what we can provide or what they can provide from an IT standpoint is an obligation of means. So we do the best to enable this from a technical standpoint, but we cannot guarantee it is working. So we do have quite large issues between what the legislator is intending to do and the technology, which is not really allowing what we want to put in place. The issue is that there are huge sanctions which can be 5 to 10% of the annual worldwide turnover in case of breach. So it's for funds it's a bit tricky, but for an asset manager you see what it means actually. You have also sanctions at the level of individual, not only the company. So if we could see one employee breaching, then that employee could theoretically be himself or herself liable. Fifth and fourth AML directive. We have seen that there is a lot of, as you mentioned, a lot of requirements in relation to transparency. AML stands for anti-money laundering, so there is still a great focus on money laundering and rules to put in place to avoid money laundering. In 2015, The fourth AML directive has been in place, or maybe before, but it is to be implemented in Luxembourg and already amended shortly. The interesting point is that there is a broadened scope of information in the sense that there will be a requirement in Europe to have two, if I may say, register of beneficial owners. So all companies, commercial companies, be it funds or not, will be required to have a register or to disclose their beneficial owners. And there will be two registers in the meaning that one will be available to all authorities, tax authorities, supervisory authorities, and one other will be available with the lesser amount of information to people on a need-to-know basis. So maybe it will ease our acceptance process, but at the end of the day, there will be no way to escape anymore or to set up funds or other companies to try to package wealth, inheritance, or to escape for whatever taxation or seek better taxation somewhere. There is also a broader scope of incrimination, which includes, besides casinos, online, etc., tax crimes as predicated offense. It means aggravated fraud. So tax fraud, simple tax fraud is not foreseen. And beside all the stats I have put here, I think that the interesting thing about the fourth AML directive is that since it will incriminate tax frauds, the question is first, is there a real difference between tax fraud and tax evasion? And am I still allowed to use legal means to have a tax-efficient treatment? And what does it mean? So you go, and I'm saying that you go and you see a Big Four firm and they put in place some tax efficiency process for your investors or for you, for the payment of management fees or performance fees. And the question is that, can it be challenged by the authority in which there is, or in the home country authority, where tax should have been paid while it has not been paid. So I think in the future it will give rise to a lot of discussions between countries and for administrative courts. In Luxembourg, there is a circular from the authority which gives some color also on what could be key indicators for tax fraud. And there are some cumulative or non-cumulative, it depends, criteria, but one of the criteria is also to avoid forum shopping. And that if you have private equity investments, for instance, you will be familiar with this. Sometimes you see that there is no economic activity except one SPV in Ireland, in the Netherlands, or in Luxembourg, just for the benefit of the double taxation treaties. So that single company in the Netherlands, whilst you have activities maybe in Germany or in Poland, and you are living in Brazil with the asset management company or the fund, could indeed raise a red light for the services providers to say, what is the rationale for having that company here, and explain me your business, etc., etc. And if you don't collaborate, or if the service provider would consider that maybe you're hiding something, they have an obligation to declare suspicion. So it's really going quite far, and it's quite new, so we'll see what it will be about. I'm sure that tax specialists will find some way to go around that, but I think this is a real point of attention to consider. At the level of the fifth AML directive, and I will finish maybe on fintech maybe also, it's not really a directive, actually it's a proposal that was deposited last year by your parliament to put in scope of AML subject also blockchain companies, meaning institutions issuing cryptocurrencies or dealing or active in the cryptocurrency crypto asset world. The definition of cryptocurrencies in Europe is not harmonized. There is a proposition from the European Association of Banks. So we are not so sophisticated for dumping as in the US, but it will come. The point is of putting into the scope of AML companies blockchain related or crypto assets related. I think it's good maybe for you and for us, because we are AML subjects also, but it has maybe burden and burden cost and a cost per se, because as you mentioned, it might be contrary to the principle of flexibility, etc., etc. So we'll see. It's just a project. We'll see how it will be. But we have seen in the world that a lot of jurisdictions outside Europe also regulating crypto assets and cryptocurrencies. So I think that maybe in 10 years' time it will be, we will be there and everything will be harmonized. But for the time being, it's still, everyone is still struggling with qualification. Is it subject to AML or not? So there are a huge discussion in this respect. This is what I wanted to touch bases today. Thank you.
Ingrid, thank you very much. Muito obrigado. Realmente era uma pauta ambiciosa que a gente tinha de alguma forma encomendado, então agradeço a tua dedicação para a gente tentar realmente passar para todos uma informação bastante completa no cenário europeu. Passamos então para algumas perguntas. Eu começo com o Jesse. So I'll switch to English, so just to make sure that I make the right question. Jesse, you mentioned earlier that investment managers, so the principles of a Brazilian investment managers can go to the United States, can access some institutional clients, have to be worried about the compensation of that person, so should not be a percentage of whatever is raised on such visits and things like that. And I am aware that there is this pre-existing relationship concept that makes a lot of difference towards knowing the client that you're offering, that the client is able to purchase your fund and things like that. Can you explain a little bit more of this and how that helps and what should be avoided without knowing or without having this pre-existing concept in place, and how can I reach that concept?
Sure, thank you. Let's see. Okay, thank you. So there are two thoughts there. One is the fund managers personnel selling to U.S. persons, and the key thing to keep in mind is what's called a salesman's stake. So if a fund manager's personnel have only an interest in selling in the short term in order to make the money and then not worry about the customer anymore, that is broker-dealer like. And then it's a little bit better if the idea is to have a long-standing relationship with the buyer, put them into a fund, and have the seller's compensation based on the success of the fund manager, of the enterprise over time, and not just a simple 3% one-time payment. So that goes a little bit to the idea of what the seller should be thinking about. On the pre-existing relationship, that moves from the Exchange Act concept that I mentioned to the Securities Act concept, and they all are mixed together. The pre-existing relationship helps establish a Regulation D compliant offering. The first element of a Regulation D offering is no public offering. So an offering to somebody that the fund manager does not know runs a risk of seeming public. It won't happen the first person that you meet, but if you meet 1,000 new people that you've never met, that looks a little bit like a public offering. A general solicitation is the term. If you instead meet with investors with whom you have a pre-existing relationship of some kind, and that helps you establish that they're an accredited investor, that this might be a suitable investment for them, all of that is very useful to establish that there is not an actual public offering. So in the scenario you described, we're worried about both avoiding a public offering and avoiding broker-dealer conduct. And for each element, it helps to have a piece of paper with some bullet points or a policy, just an easy-to-follow procedure that could be understood, that helps the marketer understand what they should not do how they should not hold themselves out. They should hold themselves out as a professional engaged in the enterprise and not as a marketer, and they should focus on the long-term prospects of the enterprise and not this immediate marketing issue. And the same thing goes with public offerings and helping to make sure that the proper statements are made and avoided in a large scale or among people that you haven't met before. And so that was an interesting question of wrapping together two of the Securities Acts into one primary issue.
And toward the same end, I imagine that if I, as the principal or the sellers of the investment manager, if I enter into the U.S. and do my visits and get out of the U.S. is one thing. Maybe to establish an office in the U.S. may change a lot of this concept, or potentially can raise many other questions. Even though I really, wanted to have this office only to, have a place to send my emails and a place to work, and not really be a selling a room or selling effort. Can you, of course, in a high level, discuss a little bit of that? That should be completely avoided. This can raise, potential and great risks, or this is something that can be envisaged with some cautious. Can you just walk us through this issue?
Sure, happy to.
Can I just make an insert in this question? When, for some reason, I hire a family office, a multi-family office there, and this family office has a bunch of investors. Just to say that eventually can have as client of my fund a multi-family officer, and this family office has a bunch of investors behind them. It's a public offering. How can I differentiate the public offering or not public offering? My client's not the final beneficial owners, but the multi-family office itself, and I'd not pay anything for them.
Sure. So first, opening an office in the United States depends on the purpose of the office. So if the only purpose is marketing, that's a less helpful fact, because we want the people who do the marketing to have another role, other substantive duties, and a goal to help the overall enterprise of the fund investment manager, and not just to market in the short term. So when setting up that office, it would be important to have some other purpose of the office other than solely marketing. Also, on the investment advisory side, I would mention that to be a foreign private advisor, the advisor must have no place of business in the United States. Now, the word place of business has a bit of a definition, but it is the first step is it's in the United States, and so you have to be careful about avoiding having a place of business in the United States if you didn't intend to, and if that would cause a regulatory requirement that you have not anticipated or intended. When an investment advisor deals with a wealth manager, for example, many advisors give advice to multifamily office or wealth managers, and that wealth manager then disseminates the advice to its own client base. It is possible to set up an arrangement so that the advisor gives advice to the wealth manager as its client, and then is not giving the investment advice to all of the underlying individuals. But it's also possible to find yourself giving advice to all of those individuals because the questions start coming in and you're giving customized advice rather than more generic advice that is geared toward the wealth management company or geared toward the individual investors looking through. So that is something to take care of when advising a wealth management company without intending to cause all of the wealth manager's clients to become your clients. When issuing securities, marketing securities to a wealth manager has a yes and a no. So the way to something to avoid is to avoid having that wealth manager engage in what could be considered a public offering on behalf of the fund. So if the fund engages somebody to sell the fund to its customers or just markets the product to the wealth manager, one of the important pieces of paper might be an agreement that the wealth manager will not publicly offer, that they will only privately place or privately recommend the security to its customers who are accredited investors, and in general to avoid a public offering. But that is a good question, because simply engaging with a wealth manager and then saying I only dealt with one person doesn't mean that that marketing effort does not reach the public. So it is certainly something to take care of and to do carefully.
Thank you, Jesse. Switching back to Europe or to Luxembourg, Ingrid, let's say that I'm a Brazilian investment manager and I'm willing to get the benefit, if possible, of the passport, of the IFMD passport. Let's say that I want to make the efforts in order to do so. So I'll set up a Luxembourg fund, either to be the investment manager directly or to be a delegate, sub advisor. My questions are, first, currently, if it's really possible to do so, meaning I'm a Brazilian investment manager only, so I'll not set up any entity in Luxembourg. Let's say that's the first idea. What's really the benefit of the passport? Meaning, can I access investors in whole Europe, or of course I have to notify other member states? I really want to understand, and the question is really to understand the real benefits of the passport, and what are the efforts that I, as an investment manager in Brazil, will have to make. So, for example, what are the requirements for this registration or this authorization to be IFMD, and what is the ongoing requirements? Meaning, what type of information do I have to provide to the authority that I registered, and things like that. I mean, I just wanted to understand the benefit of the passport and the struggle to get such benefit.
So I will simplify the answer. You would not benefit from the passport yourself, so it's easy. Now the point is that for the time being, under the IFMD, the third country passport is not available today. It should be available soon, as I said, once the EU Commission would issue its opinion about, we don't know who is available, who is eligible, or I decide to implement the third country passport. So the best option would be to have your funds in Europe to target European investors with the EU IFM third party. It can be also a EU IFM which would be in another country. It does not need to be obviously in Luxembourg. So that IFM would apply its management passport to manage the. Let's imagine it's in Spain. Or Italy. I think they are better managers. So in Italy, they passport the management. In Luxembourg, said they do manage the fund, and they appoint you as sub-investment manager, so that just a portion of their duties are subdelegated. So you would have the direct portfolio management access, and the passport for distribution would be at the level of the IFM, the Italian IFM, and that IFM would notify UK, for the time being France and Germany, which are the main markets, and Italy, to say, I'm managing that fund, I want to passport, to target publicly. That would be a public offer under each of the countries, and that's a simplified process of 2 months. So after 2 months, you can distribute and target and publicly offer. So do seminars, do roadshows, have the prospectus at the bank in all these countries. And the benefit is to raise capital, because we all discuss a lot, but the real value is investors. How can I target? How can I raise or increase my investor basis? In terms of requirements for you, as I mentioned previously, the IFM would be responsible for IFM compliance. But per se, if it says, okay, I do comply with all the the placement order policies, best execution policies, governance, whatever they have as policies. How can they say we comply whilst they don't have any view on what you are doing? They don't know what are your policies internally. So the best way is to contractually oblige you as brand asset manager by delegation to comply with their requirements. So in practice, you'll have to visit what are EU requirements applying to that IFM and what am I required to comply with contractually. It's a question of policies at the end of the day, merely. And of course, it has a cost if you need to implement other policies and procedures that could also impact your business model. But as I said, I'm not sure this has a huge impact, actually. In terms of, and beside the procedures, it's also a question, as you properly mentioned, of transparency, because the IFM, our Italian IFM, will have to report to the authorities in terms of they are reporting to authorities and they are reporting to investors. So more transparency about trade, about periodical evaluation, periodical NAV. So we'll have also yourself to do reporting to your IFM at the level of your transaction on the portfolio, so that IFM could in turn return the reporting to the authorities and to the investors.
Thank you, Ingrid. And so as I understand, it seems that for the Brazilian investment manager, currently the AFMD is more of a burden than a benefit, meaning directly he will not able to access the benefit. He would have to rely on, as you said, the Spanish IFM or something like that, right? I mean,
yes and no. Sorry, if I'm interrupting. Yes and no, because at the end of the day, you would have more investors. This is a way to be able to manage a fund, to do a track record on that fund.
But not directly. You
not
have always to rely on someone that is authorized, as long as the Brazil does not make all the efforts with the European authorities.
Yeah, agreed. Well, to me, maybe because I'm from Luxembourg, but what they have developed in Luxembourg is sort of third-party IFM, because at the end of the day, they see. At the end of the day, that's merely a check the box. That's a formality. I need to check the box. I need to have an IFM. Okay, I have an IFM. But the real management skills will be at your level. And we see also that structure used a lot for non-EU IFM, indeed, but also because investors are usually investing because of the skills of the asset manager, because of the track record of the asset manager. So it's not always the IFM, except maybe for the big groups, asset managers, but it's not always the IFM which is driving and raising capital from investors. Because if I give you some names of IFM in Luxembourg, maybe you don't know them. It's really the asset manager. So you will be the marketing, not in the meaning of distribution, but you will be the reason why they invest your funds. But I don't know, it's a tricky question indeed. The question is, would I like to have under management trillions of assets? Then I need to raise capital maybe outside of Brazil and then also in Europe. Or at the end of the day, I don't want to get the burden and to comply with the IFM indirectly. And it's a question of balance of interest, but what we see also, maybe merely from Asian IFM, is that they tend to try to avoid IFM indeed, for the time being.
Nowadays, I can still rely on the reverse solicitation, and relying on that, I don't need to make any kind of registration at all as FMID.
It depends upon the country.
And can you have a glint of the differences of understanding of reverse solicitation in the main countries like UK, Germany, France? And
but in Luxembourg and the UK, it's applying to retail and professional investors, and then it's quite large, I would say, in the sense that if you did not directly solicit and it's on behalf directly from the investor or on behalf of an investor that they want a request to subscribe, you should be fine. In France and in Germany, they will go more into the detail on how did that investor solicit you in Brazil, maybe in Italy, or how did they get to know you. So at the end of the day, it's also a question solicitation would be also looked at, is your website available to that investor and how? In Luxembourg, it's really more flexible. But the main countries, there is a real dichotomy, UK and Luxembourg and France and Germany. It's really difficult to not fall into the solicitation concept when it comes to Germany and France. Except with the fact that France, the reverse solicitation principle applies only to closed-ended fund also.
Okay. Another question is related to... sorry, yes, go ahead.
If you have a Luxembourg fund managed by a Brazilian company and you have a Luxembourg AIFMD and you want to have an investor, Brazilian or not, from Switzerland investing in this Luxembourg fund, do you need to have some kind of agent or some kind of service provider to I think the term is representative agent, or can you account on the reverse solicitation for this client invest through Switzerland?
There would be no reverse solicitation concept applying in this respect because investor would be outside the EU in Switzerland. The question would be merely, I'm targeting one investor in Switzerland, what are the Swiss rules? So they are not subject to IFM. And to my recall, last time we have analyzed that, it's quite flexible also if you target professional or institutional investors not to be requested to register in Switzerland. Because most of our clients, they do target institutional investors in Switzerland, more than one, not thousands, but more than one, and they are not registered. So the question is merely under Swiss law, which is outside the IFM, but it's quite flexible, more than in the EU actually. So for your specific case, when you invest in Switzerland, there is no representative needed. There is no solicitation question as such, because even though you will have solicited in Switzerland, depending upon the quality of your investor qualification, you do not need to register or to have a representative. But in Switzerland, you have usually they do distribute funds through representative. It's between representative and distributor. It's a sort of specific Swiss concept, and we see also a lot of German clients distributing in Switzerland through these actors. I would say Swiss actors, even though that would not be required locally. So maybe it's a question of comfort.
I would like to change the subject about new issue. New issue is something that concerns all Brazilian managers, and we are under US regulation, and from time to time we are participating in an IPO in Portugal with a European broker-dealer with a Brazilian fund, but in this somehow we have a couple of ex-Brazilian, former Brazilian citizens that changed to U.S. residency or citizenship, and then we are under new issue regulation, and we don't know how to deal with that. Is that any kind of way out or understanding how to deal with? Because in Brazilian funds, I can even differentiate shareholders, and I can't, for example, segregate the revenues as recommended by the new issue rule.
Yeah, that is complicated. Taking one step back, the way the new issue rule works is that an IPO that is being distributed by a FINRA member will have the FINRA member reach out to the buyers to confirm that they are not restricted persons. And so a Brazilian fund will from time to time receive a request for a certification saying, I or my counsel confirm that this fund is not a restricted person. And the way you can avoid restricted person status is perhaps to limit restricted persons within the fund to below a certain threshold, such as 10% of the fund. It can also instead set up a new issues class so that any restricted persons participate in all of the fund's investments except for the IPO. And that is obviously an administrative procedure that has to be built into the fund. And so if it has not been, then the fund has this difficulty in confirming whether it is a restricted person or whether it has properly taken steps to segregate profits and losses from restricted persons. Offhand, I don't recall whether there's an exception for publicly traded funds or other types of vehicles where it's impossible to track or to determine the nature of the investor as far as whether the investors in the fund are all restricted persons. But I would say that for a typical fund, it could be worth having as the investor application a questionnaire about restricted person status if the fund plans to do any IPOs, particularly to a significant event. So a fund focused on IPOs should expect the question and should probably build in the questionnaire into the overall investor questionnaire to determine eligibility and status, including on an omnibus basis, so that the omnibus broker-dealer or other financial intermediary confirms the facts on behalf of the underlying investors. And that way the fund can safely sign the certification. But it's possible that there's another way out. We could think about whether the fund, under certain circumstances, would not be a restricted person because of the nature of the fund.
Thank you. Well, first of all, thank you so much for the presentation, the three of you. I'm Marcus with Franklin Templeton, so my questions are to Ingrid. Two questions, actually. One is on the currency hedging, and the second one is on leverage. So leverage in Brazil, every time we talk about leverage, we bang our heads against the wall because we don't have a clear definition, and we simplify it by saying that the funds cannot, the clients may have to put more capital if the funds go negative. So the question is very simple. If you have a CCAF, can you say clearly that the fund cannot go negative? And what's the definition of leverage? So that's the first one. The second one is in terms of the currency hedging. I mean, the real is not a deliverable currency, and the question is basically if we can set up share classes in reais. If not, I know the regulator in Luxembourg has raised some issues about hedging, H1, H2, H3. I know there's a discussion going on. So if you can expand on that, if in the future with the third party, as you mentioned, the IFM, if we may be able to launch share classes in reais globally, if that's a possibility or not.
I'm not sure I'm able to answer to the question leverage, because to me leverage is any leverage. It's not a good definition that you could have through borrowings or through the use of derivatives. So it means for the purpose of the IFM, you need not to just say it's currency hedging because, I don't know, maybe I have an option and I believe there is no hedging. You need to look into the contract to be sure that there will be no either upside or downsides by the effect of the contract. So sometimes we have this boring service to do for the client to go into the agreement to really see whether there is leverage or not, to determine in which category we do belong. It's not an easy question, because then I could give some legal insights, but you will have risk people or management people, they would have another consideration. But in the IFM, I would say, and also in the UCITS world, it's really a question of, do I have leverage through borrowings? So I have 100, I invest in futures, and then I can, at the end of the day, invest 150, 100, 200, depending upon what is applied. Borrowings for UCITS, as you know, is limited. For certain limited and temporarily and for certain purposes. The question about currency hedging is a question which is not related to IEF world, alternative world, but to the UCITS world. There has been a position by the ESMA, which is the authority supervising all the supervisory authority of all the countries in Europe, about how or am I allowed still to have a hedge share class in a UCITS, and what are the parameters that need to be complied with. So the parameters for hedge share class is same strategy, investment policy, no contamination, and there are two that I'm forgetting, but we have a file currently. I would say no negative impact on the other share classes, shareholders, and no costs to be borne by the other share classes. This being said, the ESMA takes the view that currency hedging is not usually negatively impacting the other share classes, and then is complying with these 4 requirements. I think it's technical people have seen that, and in all the EU countries they have given position, all the professional association, all the big banks, and maybe also Franklin Templeton. I think that this might somehow and sometimes not be so straightforward, and currently we have a file where I'm not really comfortable to say to the regulator that we are ESMA compliant, and when I ask the client, it's a currency hedging, so you should be compliant, they are not willing to issue the confirmation. So I think it's still a gray area. So I think that maybe, notwithstanding what the ESMA considered technically, I think that maybe you can have currency hedging which would not be compliant with the requirements of transparency, no contamination, and segregation, etc. And with respect to the reais, I'm not aware that it is an issue for IEF, because you can have. I'm not sure that it is an issue for the CSSF. I know that the CSSF has issues with Chinese currency and Russian currencies. You have other currencies which don't have legal courses anymore. In certain countries, but that's not the case of the real. So it's not a question of the volatility of the currency that makes it uneligible. So I'm just returning to the question, what is the problem with the currency? Because at the end of the day, you cannot always have share classes like euro, dollar, and Swiss franc. At the end, it's not really interesting. We have clients, they have really a lot of panel of currencies, and there is no issue. Obviously, they don't have reais, but they have also some other currencies. So what was exactly the problem you encountered with respect to the reais? Except that, of course, it is volatile, and then you have to hedge against the dollar.
No, it's the issue that we face. It's non-deliverable, right? So that's I mean, it's definitely we have share classes in 20, close to 20 countries, and real. I was told by my colleagues there that real is not a possibility. So
I'm really dubitative with the CSSF, because the only position they take is really with respect to RMB, because RMB is you cannot take out, unless I'm missing some Brazilian, typically Brazilian rules, but you cannot liquidate your assets as you want, so you cannot take as many RMB out of China as you want. So unless you would have the same rule, which I don't believe is the case, but I don't know, there should be no reason why they do not accept the reais, because you have other currencies which are volatile. But we can take that out after, and I can contact also authority, because out of blue and anonymous basis, because it doesn't make sense.
No, and
you need to challenge.
And I wonder even if Dublin has the same. So I'm sure you're more in Lux, but I mean, since you cover usage, you know.
There is no reason why for this. Maybe not objective for Brazil, but I see the reason why for Russia and for other countries, but I miss the point here. We have a client indeed where the currency is not available anymore publicly, but just quoted in the country. That's an issue, but that's not the case here. So I don't see any barrier except volatility that would lead to consider, no, we cannot have a currency in reais. I think it's merely the services providers, maybe the Luxembourg banks, which are not dealing, which don't have access. I would see that point, because they may refuse the currency then.
Thank you.
Marcos, just to let you know, for us, I'm Roberto from Like Mason. We have some BRL share classes on Dublin platform, and we took almost 8 months to set up this first share class, the first one when we decided to hedge to BRL. But we don't have any kind of those issues. So for me, it's a surprise to hear that you guys, like Franklin Bear, having issues. I don't know if it's something related to Luxembourg, or it's a usage issue. So if you wanna help, please let me know, and then we discuss later. And do we have more time to ask questions? I just want to make a question, guys. Private placement, especially in Brazil, it's a gray area. Not even in Brazil, but it's anywhere is a gray area. And we're having a lot of discussions about that in Brazil. So how to set up a feeder fund that invests 100% of the shares abroad Brazil. and we are facing the, let's say, the catch-22. Who comes first? No? The chicken or the egg? And we need to speak to clients, or even in a one-to-one basis, to see if this product will work for them in Brazil. So, technically speaking, when you talk about a non-financial companies, what they do is they have an idea, they develop the idea, they make some tests, they call some let's say special key clients, they make some presentations and so on, and at the end, including service and so on, at the end, if they decide that this is a good idea, let's launch the idea. In Brazil, it's actually the opposite. So to be, let's say, in compliance with the legislation, you need to set up a fund, a feeder fund, before you talk to anyone, and after you set up the fund, you can talk about whatever you want about the fund. So, or you have zero, or you have all in. So, I mean, I would like to have, let's say, from Fabio, his experience and his idea about that, and about you guys, what is your experience about that? Because as I heard from France and Germany, they decided to finish, let's say, private placement, and what the solutions they have for this side. Thanks.
Yeah, maybe I think that there are two steps in your approach. The first is soliciting, but doing a market study is not always soliciting, because soliciting is soliciting subscriptions. So if you're on test, if you're prior to the setup, you cannot solicit, because you will not ask the person to invest in your fund. So I think there are ways, even in France and in Germany, and I speak just under my own control, but I think there are ways to do the market study still. Obviously, if you come and you're asset manager and you give your name, it's a bit tricky, but I think there are ways to do the market study. I'm not sure that will be ways that would be satisfactory to you. That's another question. But indeed, for the UC2, then I will leave you say your part after. I see we are working for big asset managers in France, and what I see, which is quite surprising me, is that they set up technical sub-funds in place and strange things and really technical, and after we see that after 6 months, 1 year, they close. They close because it's not working. So sometimes as asset manager you have a great idea like green bonds, sustainable whatsoever. It's trendy, but it's not raising capital. So that happens, even though all the factors show that it should work. So I don't have a clear-cut answer, but I think that we can certainly work around your market study stuff, because it doesn't mean anything to set up a new platform and see that you have to close after a while, because it's a loss of cost. For big asset managers, maybe just a good to try. But
Sure, and from a U.S. standpoint, it's very easy to solicit interest for a fund that doesn't yet exist. There are two ways you can solicit. One is solicit for investment advisory services and for fund securities. I think the regulators would view soliciting for a fund that has not been formed yet to be soliciting the securities, even though they don't exist. But in any event, yeah, that a private offering to accredited investors can be done with an idea, and you get a sense of the interest. And if there's no interest, you withdraw the product or do whatever, you change the product. That's very easy. And then for a fund launch, there's a process where you could actually form very simply the fund in a short form manner. So it doesn't have all of the complexities of a fund that has investors in it already. And the purpose of that is service providers will then begin accepting phone calls and beginning the onboarding process of a fund that exists, has a tax identification number, and has a legal personhood, and is not just an idea. And that way, the indications of interest are more credible, because now you have service providers, you have an administrator, you have an auditor, legal counsel, custodian perhaps, and even then you haven't set up all of the complicated parts of the fund, but you will have set up a simple vehicle for getting service provider relationships in hand. You build the investment strategy and documentation, and then before fund launch, you compile all of the more complicated documents and mechanics for exactly how the fund will work.
Yeah,
Thank you.
On the Brazilian side, you mentioned it perfectly. There is a conflict between the 500 CVM ruling 500, which allows you to do pilot fishing, as you're mentioning, for some issues, but the problem is that the feeder that you set up is not regulated by the 500, it's regulated by the 555, CVM ruling 555, and allows you to offer that only once you register the fund, you form the fund. That's the bad news. So that's you're perfectly right on your view. I guess the good news is to form a 555 fund is very easy, cheap, and straightforward. So even though you cannot do the pilot fishing as you could for a 500 issue and so on and so forth, the efforts in order to have the fund ready, of course, there are some costs involved. Of course, you're going to have to draft the prospectus or the bylaws and so on and so on, of course. But I believe the efforts are not so great. So to be on the safe side, this is the ideal solution. Unfortunately, not the best one, but that's the solution that we would suggest.
Maybe just one additional point, as the case may be, because I'm sure you're aware, when you have master feeder structures, it's not satisfactory to have a feeder in the EU and the master in the Cayman Island or in Brazil, because that would not benefit from the passport. There have been some discussions, whatsoever reason, people have thought that it would be easy whilst it's clear in the text. So no change on that. There will be a sort of look-through.
Thank you, guys.
Can I ask one
Sure.
other question? Nowadays, there are some firms, some private bankings, and together with some management companies, that they are offering a service that is especially to family offices. That is, they have their own structure, a SICAV or a UCITS, and they have an umbrella with a lot of sub-funds below. And they offer one of these sub-funds to a family office or to a group of individuals to access a Luxembourg vehicle to explore and to use that as the group of individuals' vehicle for investment. And my question is, there could be two situations, and I want to ask you if this is possible. If there is a fund not domiciled in Luxembourg, and you want to convert or transition, I don't know the term, into one of these sub-funds from a service provider like this. And the other situation is there is no fund, but there is a company for investment purposes, a corporate, and this could be already in Luxembourg, and you want also to transition that into this structure, this already set up structure. And of course, you said about the tax issues may be more complicated, but the viability of doing this exists. Can you convert different entities, a fund or a corporation, domiciled or not in Luxembourg, into a setup structure like this, SICAV structure with sub-funds?
First of all, I think that for you or your client to know is that if you are hosted in an existing fund under a sub-fund basis, you would not be the boss at home. So you will have to pay in any case. It's not your pro rata portion, of the services providers. So if you would have your own funds versus you have your own sub-fund in an existing structure, the fees of services providers would be exactly the same.
But there is a dilution effect, and the first documentation that is very...
Yes, but only that. So how much is it? Because I will not give names, but you have big platforms, and the funds have been set up 10 years ago, maybe or more. So formation costs have been amortized. Also, it depends whether formation costs will be amortized by the first sub-fund or on all the sub-fund for 5 years. So auditors, banks, central administration, they do fee quote on your sub-fund because it's your investment, it's your net asset value calculation, it's your investors' basis. So it might be, I don't know, 80,000 euros for you and maybe more for another or less for another. It really depends upon transaction, etc. So what is, and these platforms, they do apply a sort of setup cost of your sub-fund, which is between 10, 30, 50,000 K. So you also have to see what is convenient for you, knowing that you will be hosting your investors in their platform, and the day maybe your advisor manager, and the day you want to exit that platform, you need to make sure that the document of the fund do allow, because I've seen situations where there was not this possibility. And also you need to consider, I need to approach my investors to tell them that cooperation is sometimes from an image standpoint it's not good. So what you have asked to answer your question directly is that it's a question of redomiciliation. How do I redomicile a fund from Brazil or from Cayman into an existing company as a sub-fund, or I do create a new company. So if you have an existing fund corporation in Brazil and you want to redomicile into Luxembourg corporation fund, you do redomiciliation via a transfer of registered office. That would be the easiest. You don't lose a track record, you don't lose legal personhood, you said, because in Luxembourg it's Luxembourg English, we say personality, which is a bad translation from French. And I think this is the easiest, this is the most cost effective, this is the cheapest, no? And for you it's easy also to follow. Of course, then if you need to be redomiciled as an authorized fund, you need first to ask the approval, and then you redomicile. So if you would be hosted in a sub-fund, you have some other possibilities of sort of selling the portfolio, your portfolio to the sub-fund when it is open to subscription, and then the sub-fund issues shares to your fund in Brazil, for instance, and then you liquidate the fund in Brazil and pay in kind the shares of the underlying fund. You have some other similar or close procedures. You just have to consider tax impact in any case. I would say maybe more in this situation where you have sales than in redomiciliation situation. With one point that if you redomicile a standard vehicle fully taxable, a fund, from Brazil to Luxembourg as a fund, I'm not sure whether there is a tax impact, but maybe tax authorities would consider this is a taxable event. If you redomicile as a fully taxable company, meaning a standard company working as a fund, then you have also to consider a realization of capital gains. Am I answering your question?
Yes, yes. There is the tax issue when you're...
Yeah, and the tax issue is more or less important depending in who is the investor of the fund that will be redomiciled. For example, if it's directly owned by the Brazilian resident, for example, the family office, the individuals, this is one situation and can trigger tax issues in Brazil. If, for example, the Brazilians have a fund that invests in that other fund that will be redomiciled, that's a totally different situation, because you're not changing the property of the first fund invested by the Brazilian, you're only changing the investee or redomiciling the other fund and not the one that the Brazilian invests directly.
But you have to keep this top investment.
Yeah.
You cannot cancel it.
Yeah, because if you do, and then the triggers, and then you have to pay very close attention in how it's done. Is it a merger? Is it not a merger? Is it only subscribing for in kind? And those have different impacts and potentially tax in Brazil.
Because in Europe, usually, whether I'm generalizing, but generally merger or conversion, this is the same impact. Everything is taxable.
Yeah, in Brazil can be different the merger than the.
But the thing is, if you transfer any type of this vehicle, a fund or a corporation, into a new single structure in Luxembourg, there could be no tax issue because you're redomiciling or converting the nature of the company. But if you want to put it into an existing umbrella structure, then you would have to make some kind of subscriptions or
it's the mean how you redomicile that would maybe trigger or not tax impact.
Yeah. The process, maybe a short, not technical answer for you is it's possible to domicile, as I understand. It's possible to insert that into an existing fund, but the tricky here is really to pay attention in how it's done in order to avoid or not the tax issues in Brazil.
What we have seen with Brazilian investors is that we first, for tax reason, set up a standard company, which was owning the portfolio of assets, and then the shares of that standard companies was bought or transferred to the fund once created, and then the company in the middle was liquidated. That was what was used for tax purposes.
which type of company you said?
It was a standard company, and a special purpose vehicle,
Okay.
Not regulated, that was first created. We can discuss that if you want.
Alguma outra questão?
Just more one. Under MiFID II, there will be a new relationship between the broker-dealers and the managers under MiFID. They will need to segregate the charts into research or execution, for example. Do you think this will trigger a change in the way the charts will be done all over the world? Because it will only hurt the managers under MiFID and the broker-dealers in Europe. But somehow, I don't know if you have been hearing about this development, and if it will somehow will flow to the US or flow to the rest of the capital markets in the world.
So maybe I'll answer briefly from the US standpoint. MiFID II is requiring brokerage and research costs to be unbundled. In the United States, for the longest time, since 1975, it has been expressly legal to have an arrangement where research is provided by a broker-dealer and the investment manager takes account of the value of that research in deciding to use that broker-dealer. And that research does not have to be used for that specific client, but across its business. And there are certain disclosures that are required. But in brief, it's been a long-established process by which research and brokerage are bundled. And then what MiFID II has uncovered is that they sort of have to be bundled under U.S. law, because broker-dealers who provide research under a separate price other than incidental to their brokerage commissions, providing it under a separate price looks like investment advice. And when we went through the 4 federal securities laws, the Advisors Act is one that applies to broker-dealers who give investment advice other than merely incidental to their brokerage work. So they can call a client and say, I have a good idea, so they can give a stock tip, and then the client can trade on that stock tip. But the broker-dealer, when they provide that or provide research, it needs to be in the context of brokerage and not separately. So MiFID II is saying, unbundle it. Now, maybe in Europe, they can unbundle it, and in the United States, they do not unbundle it because they can't, and it's inconsistent. But the problem is that a U.S. advisor that has a European affiliate will find that it cannot share the research with the European affiliate because it was acquired in a bundled arrangement. And it's unable to be unbundled, and yet the research is not really able to be kept from reaching the people at the investment advisor who work in Europe. And so it's a very complicated issue right now. The SEC is considering right now, as we understand from industry discussions, allowing for the research to be unbundled with respect to cost. But it's a fairly complicated issue that has been in place since 1975 formally, and it has a lot of momentum, and there could be unintended consequences. And it would be the change of a fairly major custom and law based on what Europe has decided to do. And so there's a lot of controversy right now about what the SEC will do with respect to that specific issue. So yeah, it has bled into the US, certainly.
From an extent point, the soft dollar was not known in 75 because the first law of funds was 83 and then 88. But there was an unwritten rule, which is quite normal in Luxembourg, about soft dollars, that they were allowed subject to one disclosure in the prospectus of the fund and provided they would benefit to the funds. So of course it's not exactly the same of the new rules of unbundling, if I'm pronouncing correctly, but still there was a focus by the SEF at the level of the fund, without prejudice to what was actually happening at the level of the asset managers. But indeed there is a lot of preoccupation, and I think that smaller asset managers really relying on retrocession and so the dollars commission, this kind of stuff, will tend to disappear in any case. And there is a lot of discussion around that, even though I'm at the conferences and from my colleagues I have not heard that someone has the solution and this is what it will be. It's not really clear cut, but I can follow that within our internal groups. What is quite strange is that the MiFID is tomorrow and people does not seem to be ready. So
I guess we're just finishing. Jesse, thank you very much. Ingrid, thank you so much for this. This has been very, very, very helpful, and we hope to deliver to the Brazilian managers and service providers a very and great piece of information, so they can, either buy the presentations or either contact directly to further clarify any point. De novo, obrigado à ANBIMA pelo convite, ao Felipe, Soraya, Mari, que ajudaram a organização. Foi um prazer estar aqui falando sobre sistemas tão importantes aí para os gestores brasileiros que se aventuram mundo afora. Muito obrigado.